The Honorable, the Judges of the United States Court of Appeals for the Fourth Circuit. Oyez, oyez, oyez. All persons having any manner or form of business before the Honorable, the United States Court of Appeals for the Fourth Circuit are admonished to draw nigh and give their attention, for the court is now sitting. God save the United States and this honorable court.
Thank you. You may be seated. Good morning and welcome to the Fourth Circuit. We have two cases to hear for oral argument today, and the first is Bishop of Charleston versus Adams. Whenever you're ready, Mr. Sir.
Good morning, Your Honors, and may it please the Court, Daniel Sir, along with my colleague and friend, Rich Dukes, on behalf of the plaintiff appellants in this case. Your Honors, the District Court deserves to be reversed for the very simple reason that there was no evidence properly before it to support summary judgment in favor of the defendants. In this case, there were two expert witnesses.
Counsel, shouldn't we probably start with the obvious jurisdictional problem?
Fair enough, Your Honor. So a few weeks ago, the state introduced an affidavit from one of the defendants saying that the money is gone, essentially. There were two pots of money in this case. The first was the governor's emergency educational response funds, the so-called GEAR funds, and that money has been gone for some time, and we have acknowledged that. And then the second pot of money was this Act 154 money, which was appropriated by the General Assembly.
You not only acknowledged that, in your brief you conceded, didn't you, that you cannot apply for, receive or receive any such funds, the GEAR funds, right?
Yes, the GEAR funds are gone, Your Honor.
So why doesn't that apply to the 154 funds that are also gone?
Well, I think the key difference is the states voluntarily joining this litigation, its intervention, essentially submitting its to this court's jurisdiction and waiving its 11th Amendment immunity.
Well, that may or may not fix a sovereign immunity problem, but it doesn't fix a mootness problem. There's no state voluntarily intervened, so now we can consider a moot case doctrine, is there?
Well, I think it's because there are damages, Your Honor. We asked for damages in our amended complaint.
But counsel, but the district court said that you didn't have a damages claim because of sovereign immunity, and I understand that you now disagree, but you didn't appeal that.
Well, to be clear, Your Honor, the district court said that as to the governor and the GEAR 1 funds. The district court did not address sovereign immunity as to the Act 154 funds.
How would the sovereign immunity analysis be different?
Well,
Either you're immune or you're not.
Actually, Your Honor, the court's analysis was specific to the governor because of the nature of the discretion the governor exercised.
No, that was when the court was talking about why you didn't have standing. But the sovereign immunity point, I just don't understand. Either the state is immune from a damages award or it's not.
Well, so we've asserted that the state is not immune from a nominal damages award.
But you didn't appeal. I understand what you're asserting now, but what I'm trying to figure out is once the district court ruled against you on sovereign immunity grounds, why you didn't appeal that.
I would say we did not appeal that because it was not relevant at the time, because of the Act 154 funds, which we believe were still available. So I would concede that as to the governor, that is not, that money is not recoverable.
As I recall, the district court's footnote, it said as to all the state defendants.
I've got it right here. It's J318 footnote 3. The district court says, quote, to the extent that plaintiffs seek damages, sovereign immunity bars that relief against the official capacity defendants here. That's the footnote.
Correct. So the official capacity defendants would be the governor and the other state officials, but not the state as an entity.
Well, but the Supreme Court has long said that when you sue a state official in your official capacity, that is a suit against the state for 11th Amendment immunity purposes. So if the official capacity defendants are immune, the state is also immune.
Well, I would say no, Your Honor, because the state voluntarily chose to join the litigation.
And again, I guess not, I'm just making the point Judge Harris made. You could have appealed that ruling and you did not.
Again, I would not say that there was something to appeal because
The dismissal of your complaint for damages isn't something you can appeal?
I would say that that particular point was not something the district court ruled on. The district court ruled in the footnote you read as to the official capacity defendants. The district court did not rule as to the state. And one of the reasons for that was because the district court believed those funds were still available. And that's why the district court reached the merits in the first place.
But then, if If that's true, why is the district court's order a final judgment under 1291? Because now what you're telling me is you had a claim for nominal damages against the state, which you claim is different for your claim of nominal damages against the official capacity defendants. And now you're telling me the district court didn't rule on that point. If that's true, there's no 1291 final judgment.
Obviously, the judgment in this case was that the summary
I
judgment.
know, but unless the district court resolves all claims against all parties, there is no final judgment under 28 U.S.C. 1291.
I would say the district court did resolve all claims.
Against all parties.
Against all parties.
Well, then that means the district court dismissed your claim for nominal damages against the state.
I agree, Your Honor, and I believe it was incorrect in doing so. What we argued in our briefs here is that the Supreme Court's recent decision in the Georgia Gwinnett case allows for nominal damages when there is a constitutional violation, and that mootness is not a jurisdictional bar to nominal damages when a constitutional violation has occurred. As Justice Gorsuch, I think, puts it well in his concurrence, where there is a constitutional violation, there is an injury. And so in that case, the Supreme Court allowed nominal damages to go forward against an arm of the state, against Georgia Gwinnett College, which is a public college under the Board of Regents of the state of Georgia. It was an official state agency. And we mentioned in our brief a case from the Northern District of Georgia holding that Georgia Gwinnett College is an official state agency. And I would note as well that in their papers, the state defendants are able to point to no holding from this court saying that nominal damages are barred by sovereign immunity, and that the one case they do cite is an unpublished decision from the Sixth Circuit. So I think the recent Supreme Court decision should be sufficient for this court to feel comfortable allowing this case to go forward on a nominal damages basis.
Can I just clarify to make sure I understand your argument? There is no dispute, right, that your claim for injunctive relief is moot now. Is that right?
Yes, I believe that would be right, Your Honor. Obviously, we brought this case initially asking for injunctive relief because the funds were available. We sought a preliminary injunction initially. That was denied. And we decided to try to move expeditiously for summary judgment because of the order that we were given. The way the Judge Hendricks denied it kind of indicated she wanted a robust evidential record. We believe that's what we provided. Obviously, we believe the state didn't provide any contrary record, and that should be the reason for this court to reverse that decision.
So putting aside the forfeiture issue on damages for a minute, can you help me out with another question I have? So I understand the rule that sovereign immunity can be waived, and I understand that by voluntarily submitting yourself to the jurisdiction of the court, you waive immunity. Mm-hmm. But then, we also have this provision of the Federal Rules of Civil Procedure that says, if someone is challenging the constitutionality of a state law, that feels like something the state probably has an interest in. And so the state can intervene as a matter of right for the limited purposes of defending the constitutionality of this law. Now, as far as I can tell, at least the Supreme Court and this court have never squarely resolved the possible tension between those two things, which is that we have a rule that's designed to protect states and look out for their interests by saying, if someone's going to argue your law is unconstitutional, you probably have a right to be there, with the principle that normally if you join a lawsuit, you've waived sovereign immunity. I guess the first question is, are you aware of a Supreme Court decision or a decision by this court that sort of wrestles with resolving what seems to be an inherent tension between those two things?
I am not, Your Honor. That is a fascinating observation. Honestly, it is not one that occurred to me before.
Well,
but
it just seems,
you're right, it does. It is striking.
It just seems weird to say that the reason the state waived their sovereign immunity was because someone was filing a lawsuit saying one of the state's laws was unconstitutional, and the state says, well, we kind of have an interest in our laws not being declared unconstitutional, so we'd like to be heard. And then again, putting aside the forfeiture argument, they're now hit with an argument from your clients that by doing so, they have waived the sovereign immunity that they would otherwise have against a damages action. That seems odd.
I don't disagree. It seems odd. Obviously, the argument we made is, I think, a straightforward application of this court's holding in the Stewart case, which is that when the state voluntarily intervenes in litigation, or in that case,
I was going to say, wait, no, that's completely different. Stewart is a case where the state defendants who are sued in state court remove a case to federal court. In that case, the state is the one that's choosing to commence litigation in federal court. The state didn't choose to commence litigation in federal court here. Some other people chose to commence litigation.
Indeed, my clients.
Right. And the state says, well, if you're going to be talking about the constitutionality of our law, we would like an opportunity to participate in the discussion of the constitutionality of our law. That seems quite different from Stewart. In Stewart, the state was saying, we want to be in federal court. Just kidding, let's not be in federal court. And there's a bit of a bait and switch to what that maneuver is. But this doesn't seem like that.
I certainly wouldn't say that the state engaged in a bait and switch here, Your Honor. But I think the important part of Stewart is not the holding, it's the preceding discussion, right? So in Stewart, there's a paragraph leading up to the decision about removal specifically, where this court addresses various Supreme Court decisions dealing with, for instance, tax litigation. And the bottom line of this court's analysis of those cases is to say that these the common thread across these cases is that when the state voluntarily chooses to submit itself to this jurisdiction of a court, it cannot then turn around and say, oh, we have 11th Amendment immunity, you have no jurisdiction over us. And I think that rule does make sense, right, to the extent that what we're going for is a common sense rule here.
Well, but so your view is that notwithstanding the special privilege that the federal rules of civil procedure give to the state, what they really should have done in this case is stay out of it and let other people litigate the constitutionality of their laws, because the only alternative to doing that is exposing themselves to damages liability?
Well, I think it's where Your Honor started, which is that when we sued the governor and the other state officials, the state was functionally represented already. The state of South Carolina has chosen a sort of interesting arrangement where the attorney general is not necessarily there to defend state officials. Obviously, many other states, that's a different arrangement. But the state has made its constitutional choice and how it arranges itself, or statutory choice. And so if the attorney general on behalf of the state feels like he needs to come in beyond the official defendants, then he has to live with the consequences of that choice.
Okay, Mr. Sir, if we get beyond mootness, I know you wanted to talk about your summary judgment argument at first, and you have about 4 minutes left in this
Yeah, I
part of the
appreciate it,
argument.
Judge Thacker. Thank you.
Want to talk about that?
I do. So in this case, there were two expert witnesses. They were both provided by the plaintiffs, and they both produced comprehensive reports based on dozens of historical documents and academic articles and journals analyzing those historical documents. That was the record properly before the district court. The state filed a brief with a whole bunch of other historical materials and documents, but no expert witness to properly lay a foundation for those materials. And yet Judge Hendricks chose to grant summary judgment to the state based on the documents that it had provided and the historical story that it told based on those documents. I think that's obviously wrong. The district court should not be able to grant summary judgment against us. In other words, that all inferences should be drawn in our favor as the non-moving party, that she would grant judgment to the other side when there was no evidence before her to support that.
So I certainly agree with you if this was like a Title VII case, but tell me if I'm wrong, but my sense is that when we're doing like Arlington Heights analysis, courts don't really normally treat this as a normal Rule 56 issue. I mean, you see summary judgment granted in cases involving Arlington Heights all the time, don't you?
I think that's right, Your Honor, although one of the keys in this instance is there's a dispute over particularly Dr. Graham's expert witness testimony that the state feels, we would disagree, but the state feels that there is a disconnect between Dr. Graham's report and what he said in his deposition. And so in that instance, that seems especially the sort of thing that should go to a trial, a bench trial. That if there's a dispute over expert witnesses' interpretation of historical facts, I think we all agree on the historical facts, right? This isn't a question of fact. Everybody acknowledges these various things are true. The question is, what is the historical meaning, interpretation that we should give to these things? So it's at least a mixed question of law and fact.
What evidence did you present of disparate impact?
So one of the reports that we cited is a report from Congress, a report to Congress rather, in the 1890s, which showed enrollment in the various private schools in South Carolina at the time.
So disparate impact in 1890?
A disparate impact in 1890.
What, did you present evidence of disparate impact that this,
The
present day?
1970 version?
Yeah.
Yes, there was a separate document that looked at the number of schools that were available.
Do you have a JA site for that?
I do not, Your Honor.
Okay.
Although I think as long as we're talking about disparate impact, if I can anticipate where Your Honor might be leading, I think it's important for this court to try to figure out how to read Raymond correctly. That there are parts of the NAACP versus Raymond case which suggest that disparate impact is a threshold issue. And then there are other parts of the Raymond case that suggest that disparate impact is one of several factors, but that it is not a threshold or a determinative factor. Obviously, I believe the second reading is right, that even if we failed to show disparate impact to the satisfaction of the district court, that the other factors more than make up for that, because what the court directs us to do in Arlington Heights is undertake a holistic analysis of all of the factors. And all of the other evidence, I think, is overwhelming. And in fact, it's actually a good reason not to make disparate impact. So for instance, one of the issues in this historical circumstance is immigration. So that we were talking about immigration to the United States by persons from Catholic countries in Europe. And South Carolina's goal was to exclude immigrants from coming to the state. Well, there wouldn't necessarily be evidence of disparate impact in terms of the number of Catholics in the state, because the whole point was to keep Catholics out of the state in the first place, and so it wouldn't show up in the data. And so I think it's actually a good illustration of why disparate impact should not be a determinative factor, but rather one of several factors, because the
Okay.
historical evidence might tell a different story.
Unless your time
I see
is
that.
over your time, unless my colleagues have questions, you do have time in rebuttal.
I appreciate it, Judge
Thank you.
Thacker. Thank you.
All right, Mr. Lambert.
Judge Thacker, and may it please the court, I'd like to address the jurisdictional issues, and my friend, Mr. Heydrich, would like to address the merits. My friend on the other side has forthrightly admitted that the appellant's claims are moot as to the GEAR funds and as to any injunctive relief on the Act 154 funds. So all that's potentially left are damages claims as to the Act 154 funds. But the appellants face two hurdles they cannot overcome there. One is their own waiver of the issue, and two are their merits arguments. Judge Harris, as your question near the beginning noted, this was an issue they did not pursue and argue below. It is an issue they did not brief here. And under well-established doctrine, the issue is waived. That alone is sufficient to end the matter. But if the court were to go beyond that and find that the waiver is excusable for some reason, the argument fails on the merits. All that has fundamentally happened here, as with the state, is that it intervened to defend a state constitutional provision from a challenge under federal law. Judge Heitens, as you acknowledged or recognized in your question, it would seem awkward to tell a state your law is being challenged, but you, the state, as an entity, may not intervene unless you are willing to waive sovereign immunity. That puts the state in the precarious position of either defending its law and risking damages or hoping someone else defends the law sufficiently enough and preserving its sovereign immunity.
Is that, although, in fairness to them, I'm not sure that's true either, because, well, okay, in a federal court of appeals, a state can file an amicus brief as of right? You don't need to ask anyone's permission. You can file any amicus brief in any case you want to. Now, as I recall, there is not an amicus brief rule in district court. So I guess, are you saying the only way the state can participate as of right in the district court is by intervening?
I think that's right, Your Honor, and I think the context in which the state's intervention here is particularly important to show that. The original complaint asserted certain claims. The amended complaint asserted broader claims, some of which did not go directly to the governor or his authority under the GEAR funds. It was after the amended complaint and after a potential intervener in district court accused the governor of colluding with the plaintiffs that the governor asked the attorney general to intervene on behalf of the state. So the context here in which intervention happened makes it even, I think, clearer that this wasn't some attempt to throw sovereign immunity to the wind and jump in, but the state had a particular reason to jump in after proposed interveners, the Orangeburg County School District and the South Carolina chapter of the NAACP, had thought there was collusive litigation. To be sure, all of the parties in this case rejected that, and the district court didn't find it a credible one either, but the allegation was enough to ask the state to intervene to alleviate any potential concerns on that front. So that would take care of the state sovereign immunity waiver. That leaves them with this claim of nominal damages against the official capacity defendants under the Supreme Court's recent decision in the Georgia Gwinnett case. But it's a curious reading of that case to say the Supreme Court is now holding that nominal damages are sufficient to get over sovereign immunity in a case that never says sovereign immunity. The Supreme Court in the Georgia Gwinnett case never discussed sovereign immunity. It would seem an incredible reinterpretation of sovereign immunity law to say that official capacity defendants can be sued for nominal damages to get past sovereign immunity and deal with redressability. Fundamentally, Georgia Gwinnett is a redressability case about standing.
And you think that the cases in the real world that Gwinnett matters, I mean, imagine I sue some correctional defendants in their personal capacity for injunctive relief. They change what they're doing. So now my request for injunctive relief is moot. Gwinnett allows me to keep my case alive with a claim for not. If I'm suing like the head of the State Department of Corrections or something. Like, I'm just trying to make sure that you're not making Gwinnett a case that doesn't actually affect any situation in the real world. Maybe that's a better way of putting my question. What category of cases do you think Gwinnett actually saves then?
That's a good question, Judge Heitens. It also, I think, depends on each case what the litigation has been and the positions the official capacity defendants potentially took below. I'm not familiar with the underlying proceedings in Georgia Gwinnett to know what strategies and positions the state defendants took in that particular case. But what I do know for sure is that sovereign immunity wasn't an issue that was discussed by the Supreme Court there, and it's been bedrock law that official capacity defendants enjoy the same sovereign immunity as the state when they're sued in their official capacity.
But not when they're sued in their personal capacity.
Correct. So perhaps there's something in a personal capacity case. I think there's also something to nominal damages and redressability in cases involving private litigants, potentially. If the injunctive relief you want is moot, but there are nominal damages you can be awarded. You think back to basic trespass law. You can get $1 in nominal damages to vindicate your right. That would say a federal court retains jurisdiction under a standing analysis for Article III purposes. It's not a sovereign immunity case. I think fundamentally all of these cases are different than the cases in which my friend on the other side relies in the suggestion of mootness briefing. For example, the Clark v. Bernard case from the Supreme Court is when the state is actually asserting a claim in a bankruptcy proceeding to have its rights vindicated. The Stewart case, that long discussion was premised on the idea that states can't use procedural gamesmanship to gain tactical litigation advantages. So the state, having waived its sovereign immunity in state court, couldn't remove a case to federal court to try to regain that sovereign immunity. That's why the Stewart case focuses so heavily on the Lapidus case from the Supreme Court in 2001. And this court, in a 2013 opinion, I believe, Sansada v. Town of Nags Head, discussed Lapidus in greater detail in the context of Williamsburg County and procedural rightness for takings claims, and made clear that Lapidus, in that line of cases, is focused on procedural gamesmanship. The appellants have admitted that there's no bait and switch by the state here. There was no procedural advantage the state tried to gain. The state simply tried to ensure that it was giving a robust defense to its law when it was challenged in federal court. And the Supreme Court's decision last year in Berger v. the North Carolina State Chapter of the NAACP recognizes that states are free to structure themselves for litigation purposes however they want. As a matter of federalism, they have the right to do so. That South Carolina has chosen this particular structure and asked the Attorney General to intervene on behalf of the state, rather than necessarily representing the official capacity defendants, is a decision that South Carolina is free to make. And just as it's free under the rules and under logic. Judge Harris, did you have a question?
I did, but I wanted to let you finish your sentence, but
Please.
thank you. Can you, I don't mean to get you off on a different topic, but when exactly did this case become moot? When did the Act 154, when was the Act, when were all of the Act 154 funds otherwise allocated? So
Our position is the case was moot as to Act 154 funds when the General Assembly reappropriated that money. That happened in the 2021-2022 budget, which was enacted back the end of June 2021, admittedly before the district court summary judgment.
So you're saying the case was moot when the district court ruled on it? It didn't become moot on appeal, it was already moot?
We believe that's correct.
I thought it turned out, I think I must have misunderstood something. I thought it turned out that that was when they reappropriated $65 million, but that turned out not to be all the money?
There was $2.5 million remaining in the state's coronavirus relief fund. In full candor, Judge Harris, I don't know when that $2.5 million was.
Doesn't it matter whether I have really just been struggling. I'm trying to figure, because it matters for purposes of our analysis whether this case was moot when the district court ruled or whether it became moot on appeal. I'm assuming it's moot at all, but if it is, when it happened matters.
I think that's right. And what I don't know, and what may be hard, at least standing here today, I just can't answer, is when that last $2.5 million was reallocated under Section 12 of Act 154, as the General Assembly allowed it to be done.
But it was as of June 20th, 2022, correct? That's what the declaration says.
Correct. All of the money was dispersed by June 20th, 2022.
When before?
That was after the district court ruled, while the case was on appeal, after the briefing was completed.
Well, to the extent that I agree the request for injunctive relief was moot, but you agree that, I mean, your argument is their damages claim fails and they didn't properly appeal the dismissal of their damages claim, but that's not moot, right? The damages portion of it's not moot. Your claim there is that they forfeited any objection to it, right? But that portion of the case is not moot and has never been moot.
Correct, Judge Heitens. I want to be clear that we have the waiver argument and the merits
No, I
argument
understand,
on
right.
that. Yes.
But neither of those is a mootness argument.
Correct. That would not be moot. Anything as to the money exactly being there is going to be moot, and our position would have been moot since the money was reappropriated or reallocated.
The wonderful thing about damages claims is they can never be moot.
Precisely. So if that's all that's left, and that's not moot, which I appreciate, Judge, your point there, damages claims aren't, it fails for the reasons I've discussed already, which is the waiver and on the merits the state's allowed to intervene here. If the court has further questions on those, I'm happy to address them, as well as on the standing about the gear funds, although with that being moot, it would seem that the standing issue is no longer necessarily before the court.
But just so I understand where we are, you don't know whether the injunctive relief in this case mooted out before the district court ruled or after the district court ruled?
Standing here today, no, I do not, Judge Harris.
Okay, bit of a twist.
Judge Harris, if the court would like, I am happy to submit a 28J letter with a declaration from a state official as to when that money was reallocated. If
Yeah,
it would
I
be
think you
helpful
should.
to know. I don't think it makes a difference in the end, but, you know, if it moots out on appeal, we apply one standard about when we should vacate. If the district court didn't have authority to rule when it ruled, we obviously vacate. And so it's a slightly different analysis.
certainly, we will endeavor to find that out and submit a 28J letter for the court. If the court has no further questions, I would yield back the balance of my time.
All right, thank you. And so
Thank you,
we'll
Judge.
hear from Mr. Hydrick.
May it please the court, Thomas Hydrick for the state of South Carolina. Although I do intend to primarily address the merits, I did want to draw 2 points to the court's attention on the issue of sovereign immunity, just for the benefit of the court. First, at JA 13, where you see where Judge Hendricks granted the state's motion to intervene, you'll see that the state adopted the answer of Governor McMaster in this case, which is at JA 50. At JA 50, you'll see that the state and that Governor McMaster did specifically assert sovereign immunity in that answer. So sovereign immunity was asserted throughout the course of the litigation. As I was preparing for oral argument, even though I do intend to mostly address the merits, I also wanted to draw one other case to this court's attention, and that's the Union Electric case. And that's from the 8th Circuit in 2001. That's a cite at 366 F. 3rd 655. I think that case is important.
Did you provide that cite to opposing counsel before just now?
No, Your Honor, I did not.
All right, then he can have the opportunity to file a 28J letter on that case in response if you'd like, Mr. Sir.
Yes, Your Honor, that makes sense. But I think that that case is important for this court to consider because it deals with a factual situation that's very similar to the situation before that court. And that was the case where there were state defendants named. The Attorney General of that state moved to intervene, and the 8th Circuit concluded that that act of intervention alone did not constitute a waiver of sovereign immunity. So those 2 points I thought would be helpful on the sovereign immunity issue. But moving to the merits, if this court for any reason decides that this case is not moot, Judge Hendricks' grant of summary judgment should be affirmed because no reasonable jury could conclude that Article 11, Section 4 of the South Carolina Constitution was motivated by a discriminatory purpose of any kind. And when we're considering that, before we get into the legal analysis, I think it's very important to be clear about what Section 4 does and what it does not do. And appellants throughout this litigation, I think in good faith, have attempted to compare Section 4 to a Blaine Amendment, but as Judge Hendricks recognized, Section 4 is materially different from other no-aid provisions or so-called Blaine Amendments, and that's true for at least 2 reasons. First, it's true because Section 4 applies to all private educational institutions in our state, and that's true whether they are secular or religious. And what does it bar? Well, it only actually bars direct aid, so the money cannot flow directly to those private institutions. It does not bar indirect aid. So, for example, the state of South Carolina, as a policy decision, may choose to provide scholarship opportunities to students to pick a university of their choice, whether that's public or whether that is private, and the state has in fact done that. If you look at JA 146, you'll see a list of schools that are eligible for institutions of higher education. Those are religious institutions like Bob Jones University, and also historically black colleges and universities like Allen and Benedict. So I think it's very important to be clear that Section 4 is facially neutral and that it actually facilitates and fosters in some ways aid to private institutions of all kinds. So turning to the legal analysis, we think Judge Hendricks got the legal analysis exactly right. And I think that's true whether she cited this court's decision in Raymond or whether she simply applied the Arlington Heights framework. So going through the Arlington Heights framework, Judge Thacker, I think this is something you pointed out. There simply was no evidence of discriminatory impact in the 1970s in this case or in the present. Frankly, that's something that appellant's own expert, Dr. Graham, conceded. He acknowledged that it applies to people of all races and all religions. There's a JA site for 271 that you can see there. Turning to the second Arlington Heights factor, you can look at the sequence of events leading to the adoption of Section 4. And again, appellants offered no evidence to suggest that Section 4 was adopted in an irregular manner. I think this is a really strong contrast to a case like McCrory, where this court was very concerned about North Carolina legislature's actions following the preclearance removal by the Supreme Court. So what happened with Section 4? Where it was a period of years of deliberative study by our state, starting with the West Committee in 1966, with their final report in 1969, a supermajority of the General Assembly putting the issue on the ballot to South Carolina voters, and then the voters
Let me
approving.
go back to the disparate impact part just for a minute, because opposing counsel, I think he was arguing that disparate impact is not necessarily required to be shown under Raymond if you read it correctly in his version of how to read it. What's your response to that?
So Judge Thacker, I think that to the extent there could even be any tension between Raymond and Arlington Heights, this case is really an improper vehicle for teasing out that tension. And that's because Judge Hendricks expressly said, even if plaintiffs could get by without showing disparate impact, they still fail under the Arlington Heights factors. And I think that's because they failed to show that there was an irregular sequence of events. They've simply offered no legislative history to suggest that the South Carolina General Assembly was racially motivated at the time. And the history, which is primarily the point upon which they rely, is a much more mixed bag than I think appellants have been willing to acknowledge. I think that just two quick points on that, unless the court has any other further questions on it. One, the history of this case is significantly complicated by when the origins of South Carolina's no-aid provision actually first came to fruition. The first no-aid provision in South Carolina history actually came forth in 1868, and that was a constitutional convention that was comprised of a majority of African Americans, many of whom were former freed slaves. Those individuals decided that the state of South Carolina should not provide any type of private aid to religious institutions. And second, I think what's further complicated is that the appellants really don't offer very much evidence about the West Committee itself. Appellant's own expert conceded that the South Carolina Constitution that adopted Section 4 was effectively a new constitution in our state's history. And he also conceded the fact that the West Committee was looking towards forward progress and towards increased toleration in our state. I think if you look at the composition of that committee, it included people like Dick Riley, who was a governor of South Carolina, and President Clinton's Secretary of Education. In short, we think Judge Hendricks' grant of summary judgment on the merits should be affirmed because this case fails the Arlington Heights test, no matter how it is applied. Unless the panel has any further questions, we'll rest on our briefs.
Thank you.
Thank you.
All right, Mr. Sir, you have some rebuttal time.
I appreciate it, Judge. Thank you. Maybe let me just start with the observation. I think it is hard to say that we waive an argument that has not been crucial to the case until it became relevant. In other words,
With respect, I think that happens all the time. We hold defendants to a waiver. You can argue in the alternative. I mean, that's how waiver works.
so up until 3 weeks ago, the plaintiffs were under the impression, along with this court, that the Act 154 funds were there, that they were in the bank.
Even as a practical matter, I want to make sure I remember. I'm not sure this matters, but as a practical matter, didn't the defendants argue in their appellate brief, oh no, the Act 154 thing, that's moot too? And in your reply, you didn't say, oh, hang on, then we don't forget about our damages claim. You just said, well, we don't think all the money's gone, but if the money's all gone, then you should vacate the district court's opinion.
Yes, Your Honor. It is true that in our reply brief, we said, I think that the state had not shown the money was gone, and they didn't do.
if the money is gone, be sure to vacate the district court's opinion.
We did say that, Your Honor, correct.
Well,
We obviously believe that the Act 154 funds were there, and up until Director Gaines' affidavit, there was nothing in the record showing that they were gone. I also wanted to clarify just on the question about the amended complaint. The amended complaint was because the Gear 2 funds were added. So initially, Congress appropriated what we now call Gear 1 funds, and then Congress appropriated a second pot, Gear 2. But the Gear 2 funds that we added in the amended complaint, at no point did we add claims for or against the state that changed the nature of our litigation. So I think it's a little bit of a retelling of history to suggest that somehow the nature of the litigation or the nature of our challenge to the constitutionality of the state's constitutional provision changed, and that justified the state's decision to intervene. I also think that the answer the state gave on sovereign immunity is less than satisfactory. That his discussion of Georgia Gwinnett, the one answer he was able to suggest for you, Judge Heitens, was that it affected private parties. And obviously that can't be the case because the entire case was about a constitutional violation. The idea was that the First Amendment had been violated by the college in its application, right? It was a 1983 case. And so to suggest that the mootness analysis is for private parties, I think it's just to miss the point.
That's fair, but also I guess I'd say in fairness to your colleague, what do you say to his argument that it's really odd to read that as a case about sovereign immunity when if you do a find
Yes, Control F,
function
I've done it.
Gwinnett, I do not find the word sovereign immunity in that entire opinion.
Fair enough. I think it's interesting that subsequently the college settled for, I think, $250,000. So at least the lawyers for the college felt like they were obligated to pay more than nominal damages. I shouldn't say that. It was like $250,000 in attorney's fees, and they paid the nominal damages. So on remand, the college did not come back and say, well, we have 11th Amendment or sovereign immunity here.
Yeah, I mean, it's just given how vociferous the Supreme Court has tended to be about protecting sovereign immunity, it seems a little strange to say that they implicitly said someone doesn't have sovereign immunity in a case where there's literally no mention of sovereign immunity.
Fair enough, Your Honor. I guess I would say this court as well has never said that nominal damages are barred by sovereign immunity, and the state has been able to.
Can I ask you, just sort of given the nature of sovereign immunity, why wouldn't nominal damages be barred?
Yeah, I actually think it's a great question, Your Honor. I'm glad you asked it. I think it goes to the policy behind sovereign immunity, right? The taxpayers should not be bankrupted by things that they are not personally responsible for, right? The taxpayers didn't violate somebody's constitutional rights. Appointed officials from elected officials far removed from taxpayers did.
But hasn't the Supreme Court, I agree that's part of it, but hasn't the Supreme Court said in cases like Alden, it's not just that, it's not just money, it's also the indignity of forcing the state to be a party, of having judges tell, you
Yes,
can quote the
the
language.
litany, yes. I mean, honestly, here the answer is we didn't force the state to be a party, right? To reduce to our prior conversation, the state chose to become a
I was
party.
asking about your nominal damages argument. Why wouldn't that dignitary rationale apply just as much to $1 as it was to a gazillion dollars?
I think it would, Your Honor. I think it would. So the final thing I'll say in my last 25 seconds is the Blaine Amendment as a label used to describe the 1972 was not our label initially. It was the Attorney General's own label in a 2018 opinion letter that he wrote. And I would say we introduced plenty of legislative history. Both Speaker Solomon Blatt and Legislative Senator Marion Gressett were both very aggressive in their segregationist policies. And they were the two men. One served on the West Commission. The other was the sponsor of the West Commission amendments through the legislative process. So I think we more than covered that in the record that we did develop. With that, I see my time is about to expire. Thank you for your attention today.
All right, thank you. And thank all three of the lawyers for your very good and candid arguments today. We appreciate it. And safe travels back. Don't forget to take your microphone cover. ready to hear argument in our second and last case of the day, Colorado Bankers Life Insurance versus Academy Financial Assets. Whenever you're ready, Mr. Lieberg, do you have a microphone cover for your?
I was having trouble opening it.
Oh, okay. Do you need scissors or something? Okay.
It just won't open. Oh, there we go, there we go. Perfect.
All right. Good to go. Whenever you're ready, Mr. Lieberg.
Thank you, Your Honor. May it please the court, Matt Learberg here for the defendant, Academy Financial Assets, LLC. The revolver here has a fee-shifting provision that's quite favorable to the lender. If the lender incurs costs seeking to enforce the loan agreement, the lender is entitled to all of its out-of-pocket costs and expenses, including the reasonable fees of outside counsel that are incurred by the lender. Yet in this case, the lender asked for and the district court awarded an automatic 15% attorney's fee, $6 million in a simple collections case. The district court based that decision on a North Carolina statute, and many state and federal courts over the years have had occasion to interpret that statute at 6-21.2. None of those courts, and there are a couple dozen, has ever countenanced such a massive recovery of attorney's fees without evidence of their reasonableness coming before the court. Here, the parties expected in the contract that the lender would have to prove up its out-of-pocket costs and expenses actually incurred, and that's exactly what the lender should be
But the
required
clear
to do.
language of the statute says, the pertinent language is such provision shall be construed to mean 15% of the outstanding balance.
That's right, Your
So-
Honor.
15% is 15%. What evidence does there need to be?
Sure. So I think the best way to look at subsection 2 is the way that Judge Hummerkaus analyzed it just recently. And I believe it's in the case In re Shore, and this is a 2020 case that's cited in the briefs. What the judge said is that 1 and 2 are not written in parallel structure. Subsection 1, everyone agrees, I believe all of the parties agree, and all of the cases agree, that if you fall within subsection 1, proof is required. Everybody agrees on that. The question is, what does 2 mean? In subsection 2, what the judge said is 2 is a function, it serves the function of supplying a percentage cap.
I guess,
where it's
first of all,
missing.
do you agree that 2 is the applicable statute here to your case?
Well, so to rewind, I think that where you start is attorney's fees provisions are not enforceable in North Carolina unless there's a statute. The flush language at the very beginning of this statute says empowers and allows, kind of authorizes attorney's fees to be shifted in certain contracts. So I think you could stop there. You could just stop and say the parties have written out 70-some words as to how fees should be awarded. The statute allows it in the flush language. The end.
Except that doesn't square with the statute at all, because 1 and 2 then says there are 2 categories. It says if such note, conditional sale contract, or other evidence of indebt. Okay, do you agree that this is a note, conditional sale contract, or other evidence of indebtedness?
That's not in dispute.
Okay, so then I have the statute, a 1 and a 2, and it says if such note, conditional sales contract, or other evidence of indebtedness provides for attorney's fees. Do you agree that this contract provides for attorney's fees?
Correct.
Okay, so then it seems pretty clear to me as a matter of basic statutory construction, this is either a 1 or a 2 case. It can't be neither a 1 or a 2 case.
And in fairness, that's what most of the courts who've looked at it have said.
Okay, so to go back to Judge Thacker's question, is this a 1 or a 2 case?
Right, so it's both. And the reason.
Well, but the statute, you know what I'm going to say next. What I'm going to say next is it says, it says if it provides for attorney's fees in some specified percentage of the outstanding balance, then 1 rule applies. And then if it doesn't provide for payment of fees in a percentage, another rule applies. That seems to cover the water and says we're either in 1 or we're in 2, but we can't be in both 1 and 2.
And that's exactly that is not correct.
Okay.
Here's why. 1 and 2 do not have a parallel structure. They do in the first part in terms of if you have a contract that has a particular percentage, then you're within 1 and only 1. The question is, what is the function of subsection 2? Subsection 2 merely says, it's a gap-filling provision. It says that if you have a contract that doesn't specify a specific percentage, and it tells you how to read that contract. It says such
Don't we have a
provision.
contract that doesn't specify a specific percentage?
Correct.
Okay, go on then.
So then we start.
So this one applies.
Absolutely, if you agree, if you don't agree that the flush language takes care of it, then yes, we go to 2 because we don't have a percentage in the contract. And what does 2 tell us to do? It says such provision shall be construed to mean 15%. So essentially, you take the language that's already in the contract and you write in the percentage is 15. And then you go back to 1, and 1 says,
okay,
and everybody agrees that 1 requires evidence. So if the contract
is there a
says.
case law that says that both 1 and 2 apply at the same
Yes.
time? Which is your best case on that?
The best case on that is In re Shore. It's a Middle District of North Carolina bankruptcy case cited in the briefs. It's 2020 Westlaw 3125280. And it's very well reasoned and detailed. There are actually a series of 3 opinions by Judge Hummerkaus.
Just to be clear, this is a decision from a bankruptcy court. Is that
Correct.
Okay.
And for many, as Your Honor can see in the briefs, many of these kind of cases arise in federal court in bankruptcy.
But I guess I'm just establishing, if the North Carolina Supreme Court had answered this question, no matter, they could interpret this statute to mean literally anything in the world they want, and we'd be bound by it. But anyone other than them, all we're really trying to do is to predict what they would say, what the North Carolina Supreme Court would say, right?
That's exactly right. And at the end of the day, the court needs to just review the 24 cases on point and look at, for example, the fact that in the last 25 years, 9 cases have gone our way and 1 contested case has gone the other way. 1. That in the last 25 years. So that's indicative of something, right? I mean, none of those are the North Carolina Supreme Court because, as Your Honor notes, we don't know what the North Carolina Supreme Court would do.
Can I ask you a question about, you've said a couple of times, nobody doubts that you need proof under subsection 1. I just want to make sure I understand what you mean. If the contract says attorney's fees in the amount of 7% of the outstanding balance, everybody agrees you would still have to prove up that that is a reasonable attorney's
They
fee? I don't
do,
think
and
that's right.
it's so odd because subsection 1, I agree with you, subsection 1 never says you must prove, but both parties have cited in their briefs, and all of the cases appear to agree, that subsection 1 does require you to prove that up. It's not an automatic. There's nothing automatic under
So
subsection.
we're like well past any kind of a literal interpretation of this provision, right? Because also like a specific percentage means anything under 15% or usual hourly rates or anything over 10%, right? Like no one is construing this literally at this point.
I think that's the problem, and that's why the courts keep wrestling with it. I mean, take, for example, when you have cases where there's $3,000 in fees at issue, sometimes the analysis is quick and dirty, and the courts just say, that's fine, close enough, 50%. The ones where the courts really pause and spend a lot of time analyzing it are the ones like this case, where the difference is substantial. I mean, in this case, it's not in the record. There's no evidence as to how much the plaintiffs have spent trying to pursue this case. I think, reasonably speaking, there's no way it's anywhere near $6 million. That evidence, the district court didn't require that evidence to be submitted, so we don't know. But let's look at a couple of cases where these kind of big dollar numbers are at issue.
Can I ask you, when you're doing that, to specify when we're citing North Carolina decisions and when we're citing federal court decisions? Because, I mean, sort of with all due respect, under the Erie Doctrine, it doesn't really matter what a federal bankruptcy court predicts that a North Carolina statute means in terms of helping us figure out what a North Carolina court would say. I mean, the Supreme Court has literally said that under Erie, we are forbidden from deferring to trial courts about what state law means. So could you specify when you're talking about actual North Carolina court decisions?
Yes, and I'm going to try and address both of those at the same time. First, on the kind of big dollar cases, there are 2 that I'd like to call the court's attention to. The first has a lengthy analysis. It's In re Briar Creek. It's again a bankruptcy of Eastern District case from 2013. And the difference between a flat fee and prove up your fees is $16 million in that case. Those are the kind of numbers that the court paused and said, there's no way I'm going to award just a blanket $16 million. And the court ends up deciding, what do you do? I mean, the question the court poses, and this is a great case to review for the conundrum we're in. What do you do when the parties go on at length in the contract as to how they think fees should be calculated? Just like here, This isn't you get a reasonable attorney's fee, period. There's 70 words that try and describe what the parties are trying to do. And the question is, does the statute just ignore that? Is the statute so clear that we should just ignore what the parties negotiated? That's the question before the court, and that's the question that was before the court in Briar Creek. Ultimately, the court decided, no way. After examining lots of cases from state and federal court, the court looked back at a North Carolina Court of Appeals case, Barker versus AG, and said, that's the closest analogy. That's a case where the parties in the contract said, we are trying to limit this to costs incurred. And the court said, I'm not going to ignore the contract. We're going to do, in Barker, the North Carolina Court of Appeals says, we're not going to ignore the contract. You have to prove it up. And that's what the judge did in the Briar Creek
Can I ask you a
case.
question about, so I understand what you're saying about Barker. And Barker, if I'm remembering, is the North Carolina case where the court says, look, 2 is just a fallback provision. If there's no indication of what the parties had in mind, then this is a 1 case. But you opened your argument by saying, no, this is a 2 case. And that is what confuses me. I thought under Barker, this would be a 1 case, not a 2 case.
Right, and the courts have dealt with it in different ways. And I think that whether you call it a 1 case because the parties have written language that says this is how we want it to go, and it goes straight to 1, which is what happens in Barker, or you kind of use 2 as the bankruptcy court has looked at and says 2 is a gap filler. And if you don't have a percentage, you kind of pencil in 15, and then you're right back in 1. Those are 2 different ways to approach it. They both end up in the same place, which is that you have to drive through subsection 1 to figure out how to award fees. But I do want to focus on Judge Hyten's question about what the state has done. Here's what the state has done. In North Carolina, similar to the federal courts, the first Court of Appeals panel to get to an issue gets to say what the law is at that level. Of course, it doesn't bind the Supreme Court, but it binds the Court of Appeals. And I think the oldest case that the parties have found is the Coastal Products case way back in, I believe, the early 90s. That case says, it examines it and says this is a fallback provision and you don't get an automatic 15%. That binds all future Court of Appeals panels in North Carolina. Barker comes after that. Barker actually goes up to our Supreme Court and is affirmed on different grounds. So that's kind of a relevant data point. We get to Trull in 1996. That case, the Court of Appeals went the other way. And unfortunately, I hate to say it, but I love my home court, but this happens from time to time. And that North Carolina Court of Appeals panel came out a different way. That case went up to our Supreme Court on the dissent. And as mentioned in the briefs, and we can discuss this if your honors have questions about it, under North Carolina appellate practice, the scope of what the Supreme Court affirmed in its per curiam affirmance is just the narrow issue that was covered in the dissent. That's well-established North Carolina procedural law. So when you look at what the North Carolina Court of Appeals have done, you've got the first case controls under a North Carolina case called in re civil penalty. First case controls, so that's what the law should have been. Various Court of Appeals opinions have kind of gone a couple different ways over time. But the modern trend, and in fact, every single North Carolina Court of Appeals panel to consider this issue since 1996 has come out in our favor.
But what do you bet the pre-96 cases?
They're a mixed bag.
So, for example, you agree that RC Associates says that under subsection 2, the legislature has predetermined that 15% is a reasonable amount. That is language from the North Carolina Court of Appeals.
Absolutely. And this is what happens, unfortunately, from time to time, is the panels...
But that's not just Trull. It's not just that they said that once. I mean, the problem is there appear to be decisions of the North Carolina Court of Appeals saying literally both things.
That is exactly correct.
More than one.
It is not the first time. What we're supposed to do when we're in state court is you start with the first one, and it's Coastal Products. That's in our favor. All the rest of them are wrong.
Well, maybe that's what you're supposed to do in North Carolina, but that's not our job. Our job is to predict what the North Carolina Supreme Court would do, and of which the decisions of the state intermediate appellate court are evidence of what the state said. But we're not. It is not our job to parse who's right under what precedent is controlling of the North Carolina Court of Appeals.
That's true. That's true. And I only offer that because of the Trull argument that's being offered by the other side. So what is the best evidence of what our current North Carolina Supreme Court would do? I would say the last 25 years of North Carolina Court of Appeals opinions is a pretty good guess. Some of those judges are now on our Supreme Court.
Well, the last 25 years except Trull.
Well, Trull's 25.
Sorry, Trull. Okay, so every decision sends Trull. Okay.
That's a better way to put it. Every decision.
Now, although in fairness, I looked at the 2 most recent decisions, and tell me if I'm wrong about this, but the 2 most recent decisions in the North Carolina Court of Appeals I saw, this question wasn't really presented. These were cases in which the the party against whom fees had been awarding, as I recall, in neither of those cases was the debate in those cases before the North Carolina Court of Appeals whether you had to go to 15. Those both involved cases where a trial court awarded less than 15, and the party against whom fees had been awarded argued the fees should be even lower than 15. But the party who'd gotten an award of less than 15 was not, you know what I'm saying? I don't remember either of those decisions where a party that got less than 15 was arguing they should have gotten 15. It was a case where a party had gotten less than 15, was defending the fee award that they had gotten. So it doesn't seem like either of those cases sort of squarely presented this question, right?
I think you're right, Your Honor, in terms of what was ultimately the holding of each of those cases, but I would commend you to the Tellerant leasing case from 2009. That's a North Carolina Court of Appeals opinion that cites coastal products and says evidence is required. You've got to prove up your fees. You're right. Ultimately, the holding didn't turn on that, but it reaffirms that that is the law in North Carolina. And ultimately, the fact that all of the recent North Carolina Court of Appeals cases and all but one of the contested federal cases in the last 25 years has gone our way. And just to clarify, the reason I say contested is there were actually 3 federal cases that on a glance appeared to support the lender. 2 of them, the defendant either defaulted or didn't respond, and the judge just kind of accepted what the lender said. And in fact, the only federal case that goes in the lender's favor, I think has some interesting language. This is the Baker versus Taylor case from 2015. Cites Trull, doesn't cite a single other case from North Carolina State Court. Decides that subsection 1 requires evidence, but subsection 2 does not. And then says, even if this interpretation is wrong, it is readily apparent that the fees would exceed 15% anyway. That's the best case, the best recent case that the lender has. But ultimately the courts are wrestling with this policy question, right? Which is they're trying to read this statute and make sense of it. And as Judge Harris noted, that's not as easy as it might appear to have it be coherent and make sense. And the courts ultimately are saying in cases where there's not a lot at stake, they might kind of touch on it and move on. But in the 2 main cases where there are millions and millions of dollars at stake, they both came out in our favor. That's the Briar Creek case, and then the Ergs 2 versus Licton case from Judge Flanagan in the Eastern District. That one, ironically, is another one where it was a $40 million loan times 50% equals $6 million. And Judge Flanagan says, the loan agreement showed that the parties were trying to limit fees. I'm going to respect that. I require evidence. That's exactly the analysis the district court should have done here.
I'm sorry, which case was that?
That's Ergs, E-R-G-S, Ergs 2 LLC, mellifluous name, if any, versus Licton, 2013 Eastern District of North Carolina. I'd like to reserve the rest of my time for rebuttal, please.
All right, thank you.
Thank you.
We'll hear from Ms. Fussell.
Good morning. May it please the court. With respect to the award of the attorney's fees, the district court properly awarded fees in the amount of 15% of the outstanding balance of the loan. Judge Heitens, as you appropriately pointed out, when sitting in diversity jurisdiction as the district court was here, they are required to look at state law and determine what the state's highest court would have done. As this court has said, when applying state law, federal courts have always found the road straighter and the going smoother when instead of blazing new paths, they restrict their travels to the pavement. That is exactly what Judge Dever did here.
Well, except opposing counsel says we would be blazing new paths. He kept saying that no case since 1996 has gone your way. They're all in his favor.
Your Honor, we would disagree that the more recent cases, specifically, I believe he was citing the Tellerant case and the Bombardier case, go in his favor. When you look at Tellerant, which is a 2009 North Carolina Court of Appeals case, the lender in that case was actually seeking fees in excess of the 15% cap in the amount of attorney's fees, in the amount of the outstanding balance that was at issue before the district court. The lenders were seeking fees from ancillary litigation where the parties had sought to sell items to reduce the amount that was owed. There was a bankruptcy proceeding, and the lender was seeking fees from those other actions. And the court said, well, it's more than 15% of what was owed in this particular case, but when you look at the entire amount that the borrower owed in full, it's actually less than 15%, and affirmed the district court's award. So again, that wasn't a case where the issue of a subsection 2 case was squarely at issue. This is a subsection 2 case. Where?
Can I ask about that?
Yes, Your Honor.
I mean, there is the coastal production Barker line of cases, and they seem to suggest that Section 2 is reserved for cases where, you know, it just says reasonable fees, and we have no idea what the parties had in mind by that, and so it's a fallback provision for that. But if there's some sort of specific understanding between the parties about what that fee award will look like, then you're up in Section 1. Why is that wrong?
Coastal production actually supports Judge Devers' findings here. First, the majority of coastal production was applying, it is a subsection 1 case. The fee provision in that case said, I believe it was a minimum of 10%.
Which is not a specified percentage.
The North Carolina Court of Appeals held that was enough for it to be a specified percentage of 10%.
It's not a specified percentage in the way we normally understand those terms.
The North Carolina Court of Appeals said when you have a minimum of 10% or a maximum of something, that is enough of a specified percentage.
We're sort of talking past each other a little bit here, but I think that once you read Barker, it becomes clear that the reason we are incredibly generously construing what counts as a specified percentage in ways that really do not track normal English usage is because we are limiting subsection 2 to the category of cases where we just have no idea what the parties have in mind. If they'll give us a hint, we have in mind something more than 10%, then we're in number 1.
Yes, Your Honor, and here the case is a subsection 2 case, but because what the parties agreed to in the revolving credit agreement is that the borrower academy shall pay all out-of-pocket costs and expenses, including the reasonable fees of outside counsel. And under the North Carolina statute and under subsection 2, where the parties say that they will pay reasonable fees, that is what the North Carolina legislature is defining.
If this contract had used the word usual instead of reasonable, then it would be a subsection 1 case, right? Because then it's just Barker.
I think, Your Honor, if the contract had used usual as opposed to reasonable, we may be in subsection 1 where the parties would be looking at the exact amount.
Doesn't that seem sort of, I mean, it's possible the North Carolina Supreme Court would take that formalistic an approach to this, but what, again, this last time I'll sort of ask this question, I can't put together the case law in any way that sort of makes sense except for a through line that nobody is reading the statute literally or formally. Nobody is doing that.
The Court of Appeals in the cases of Trull and Devereaux Properties and Nucor Corp. Versus General Bearing and RC Associates are reading the statute literally. They're saying where the parties agreed to pay reasonable attorney's fees, the lender is entitled to 15% of the attorney's fees without additional proof.
But it's clear and undisputed, right? I think everybody is not disputing that once, it's fine, go on. Yeah.
Well, I have a question. Under your argument, how can parties ever limit attorney's fees in the manner that they see fit?
Yes, Your Honor, parties have done so by sort of putting cases into a subsection 1 case where they've said a minimum of 10% and a maximum of 10% based on the standard hourly rate charged and based on the number of hours actually expended. And the courts have said, okay, well, we're in subsection 1. The parties agreed to attorney's fees between 10 and 15% based on the actual amount of time expended. And so parties could do it that way.
So again, this particular provision, if they had added to the end no more than 15%, then this would be a subsection 1 case.
Yes, Your Honor. But that's not what they did here. Here they said the lender agrees to pay reasonable fees, and the North Carolina legislature has determined that where the parties say reasonable fees, that means 15% of the outstanding balance. And the North Carolina courts interpreting this, even the Court of Appeals, Trull is not an outlier here. Devereaux Properties actually overturned the trial court awarding actual fees incurred and instead said, no, trial court, you should have just awarded 15% of the outstanding balance. Same with Nucor, RC Associates, as it was pointed out earlier, actually said that 15%
So it
is
reads out the word reasonable, really.
the statute defines the term reasonable. When the parties agree to reasonable fees, the North Carolina legislature has said that is 15%.
And what do you,
It's going to be may be unreasonable. 15% may be unreasonable in some cases. Certainly, Mr. Learberg would argue it's unreasonable here.
It certainly wasn't unreasonable to the North Carolina legislature, and that is what they determined, as was their
and
prerogative.
isn't, I mean, at least one possible rationale for that, I suppose, is that we don't want fee litigation is annoying and expensive and difficult for trial courts, and maybe the North Carolina legislature just said, whenever possible, we would prefer trial courts not have to review billing sheets and figure out what reasonable time is. If you want a contract for attorney's fees, it's going to be a percentage, but we're not going to make trial courts. I mean, again, whether that's a good decision or a bad decision, I could imagine a rational legislature saying, we don't want trial courts wasting their time reviewing billing sheets.
Yes, Your Honor, it certainly does create efficiency for both the trial court and the parties. It creates certainty for the trial court and the parties.
How does it do any of that if all you have to do is say no more than 15%, and then the trial court has to figure out the reasonable fees?
Your Honor,
It doesn't do that at all.
the parties would be free to contract for that if that's what they wanted. That's just not what they did in this case.
Can I ask you a question about the 15% number and why the it just seems absurd to me. If under subsection 1 they're saying you can never get more than 15%, that is the absolute cap, why would it make sense to say, and if you don't say anything, we're giving you the absolute cap? Why would the same number be both an absolute maximum and a minimum? It's the default. If you don't contract around it, that's what you're getting. I'm just struggling to understand why that is not the most absurd structure of all time.
Your Honor, unfortunately, I don't have an answer for why the legislature wrote the statute this way.
But we do try to avoid absurd outcomes when we, and as does the North Carolina Supreme Court.
They do, Your Honor, but the cases here have found that this is not an absurd outcome to award a flat 15%.
Why can't it just be a penalty default? We have penalty default rules in contract. We have penalty default rules in tort. We sometimes say, look, if you don't specify, we're going to pick this outcome, and that outcome might be a little harsh, so maybe you should specify better. Are you familiar with the concept of a penalty default?
I am, Your Honor. While I wouldn't say that this statute is a penalty, the North Carolina courts have actually...
No, not a penalty, not in that sense, but in the sense of sometimes people who create legal rules create rules that they actually suspect that most people might not want if they bargained over the matter, and they do that as a way of incentivizing people to bargain over the matter.
It may incentivize bargaining, and in this case, the courts have said this provision is actually a safe harbor for the borrower because it requires the lender to provide notice that of the amount that's owed, and that if the borrower doesn't pay in so many days, that the lender is going to seek and may be entitled to 15% of the attorney's fees. So it actually allows the borrower a time to repay the amount actually owed without incurring any attorney's fees. Academy didn't avail itself of that safe harbor here. They said, no, we're going to litigation. In fact, we had an entire litigation process here. To the extent the parties are looking at the most recent cases, there is a June 2022 North Carolina Supreme Court case that while the majority of the case does not discuss the application of subsection 2, it is notable that in the dissent of that case, at least one North Carolina Supreme Court justice...
What case are you talking about?
Yes, Your Honor, it's Reynolds-Douglas versus Terhark.
In your brief?
No, Your Honor, it was actually out after both sides closed briefing in June of 2022.
Okay, but still, you can, if something comes, we had this in the first case, if something comes to your attention, you file a 28J letter, you let opposing counsel had an opportunity to, is this the first time he's hearing of this case too?
Yes. Maybe I can't answer that for him if he's seen it before today.
No, out of your mouth.
Out of my mouth, yes. Your Honor.
Okay, yes, you need to be fair to opposing counsel, so he'll also have the opportunity to file a 28J letter in response to this.
Yes, Your Honor.
I don't understand. Okay,
And
go ahead.
in the dissent in that case, the North Carolina Supreme Court, one justice actually discusses the application of subsection 2. And there he says it is a clear 15% rule. You look at the outstanding balance and apply a 15%. In the Terhark case, the trial court had actually awarded fees in excess of 15%. It was a $2,000 dispute and had awarded fees somewhere in the range of $28,000 or $30,000. Without discussion about the reasons for that, the North Carolina Supreme Court affirmed that award And the dissent actually said, if we were appropriately applying this statute as it's written, as it's clearly written, the party would have only been entitled to 15% of the $2,000. Academy would like to focus on the number of words in the attorney's fees provision in the contract, when in fact you should be looking at what those words say and how North Carolina statute and law applies to those words. Judge Dever correctly held that the agreement provides for reasonable attorney's fees without specifying a specific percentage. That dumps this into subsection 2, and Colorado Bankers is entitled to 15% of the outstanding balance. In this case, it happens to be $6 million. However, Academy had borrowed $40 million that remained outstanding at the time that this lawsuit was filed. Judge Dever appropriately applied the statute in this case. This $40 million is a small fraction of the money that Mr. Lindbergh and his companies have taken from Colorado Bankers, which is now insolvent. To avoid paying the contractual attorney's fees, Academy asks you to ignore North Carolina law and instead apply the non-binding decisions of bankruptcy courts out of the federal cases. Thousands of policyholders are waiting on this and numerous other courts to see if they will hold Mr. Lindbergh to his promises to repay these insolvent insurance companies back. Fortunately for Colorado Bankers policyholders, Judge Dever did exactly that, finding in favor of Colorado Bankers on summary judgment. Unless the court has other questions, we respectfully ask that his order be affirmed in all respects.
Do you have any other questions?
I do not.
All right, well, thank you for your argument. We'll hear from Mr. Learberg on rebuttal.
Thank you, Your Honor, and I'll explain more in a 28J letter, but very briefly on the Reynolds-Douglas case. Two things. First, that case actually involved the majority allowing an award of, on a small loan, an award of more than 15% based on the evidence submitted. And the dissent said, whoa, whoa, whoa. The evidence submitted might show more than 15%, but the statute says you can't give more than 15%.
Under either one or two.
Yeah, under either one or two, which is, I think, a reasonable interpretation of the statute. But in any event, if you're going to use that opinion to try and divine the thoughts of the justices, there are two things that kind of jumped out at me. One is the majority said it's important to have litigation be economically feasible. And that's why we're going to allow this kind of very small dollar amount case, allow the actual fees incurred be awarded. And the dissent said such a large award would appear to incentivize costly litigation. That was their opposition to an award that exceeded 15%. Both of those kind of policy suggestions by the justices to me suggest that they would consider, would be perhaps persuaded by the argument that a windfall of $6 million, such as in this case, would be inappropriate. The Tolerant Leasing case says, and I'll quote it, "The law requires evidence and findings of fact supporting the reasonableness of the award." That's what the North Carolina Court of Appeals said about 10 to 15 years ago. The question of the penalty default, Judge Heitens. I think that the high watermark of what the statute could reasonably mean along those lines would be that 2 is that kind of trigger. And if all you say is reasonable fees, if that's all the parties say, then maybe, following your argument, Judge, maybe there is a trigger there that jumps in. But that's not this case. This case, the parties negotiated. They said out of pocket, and they said incurred. Why would they? I mean, let's agree that if the statute is going to be interpreted that there's an automatic 15%, it is necessarily true that the courts will be ignoring the intent of the parties. That is necessarily true under the plaintiff's theory, because that's what the parties put in the contract.
Well, but that's also true if the parties say reason. I mean, I guess the statute says shall be construed. I mean, anytime a statute says a private agreement shall be construed, creates situations where the court will in fact be ignoring what the parties actually meant, right?
And in some of the cases where the delta there is 1% or something, the courts kind of look the other way. Here, that delta is the majority, if not almost all, of that $6 million award. Lastly, our best evidence on the summary judgment question, I point the court to the Met PG deal. It's an $800 million deal, October 2019, JA 291. Had that deal gone through, interest would have been cut off, and the judgment would simply be.
I mean, in fairness to your opposing counsel, you didn't argue about summary judgment in your opening argument, but It's in your briefing, and
It
we'll
is, it's in the
certainly
brief.
consider
And if
that.
the court has no further questions.
All right, do you all have questions? Thank you. Thank you both for your arguments in this really interesting sort of law school type riddle of an issue. We appreciate it. And now I'll ask the court, the clerk to adjourn court till tomorrow morning.
This honorable court stands adjourned until tomorrow morning. God save the United States and this honorable court.